Ea ka aha ho'o kolo ki ike hana ua a koa ho maila. This Honorable Supreme Court of the State of Hawaii is now reconvened.
Please call the case.
Case number SCWC-18-00057. KAUHULU o MΑNΑ et al., petitioners, plaintiffs appellants, cross appellees versus Board of Land and Natural Resources, State of Hawaii, respondent, defendant appellee, cross appellee, and Syngenta Seeds LLC and Syngenta Hawaii LLC, respondents, defendants appellees, cross appellants. Arguing for petitioners, KAUHULU o MANA et al., Lance Collins. Arguing for respondents, Syngenta Seeds LLC and Syngenta Hawaii LLC, Timothy Irons. Arguing for respondent, Board of Land and Natural Resources, State of Hawaii, Ewan Rayner. Argument on the merits.
So sorry, I thought I clicked it off. Once again, good afternoon, aloha everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo, and I'd like to welcome our substitute justice, Judge Kirsten Hammond. Judge Hammond, thank you for joining us today. During the proceeding, if a justice has a question, they'll raise their hand virtually and I'll call upon them at the earliest opportunity. And I'd like to ask our attorneys to introduce themselves in the order in which they'll be arguing. Beginning with you, Mr. Irons, I believe. Oh, Mr. Collins, I'm sorry, pardon me.
Aloha, good afternoon, Your Honors. Lance Collins for the petitioner appellant.
Thank you.
Good afternoon, Chief Justice Rechtenwald and Justices. Tim Irons on behalf of appellees, Syngenta. And
recording in progress.
Good afternoon, Chief Justice and honorable members of the Supreme Court. Ewan Rayner, arguing on behalf of the Board of Land and Natural Resources.
All right, thank you to each of you. Just to confirm, we have an hour set aside for oral argument today. Mr. Collins, you'll begin with a 15-minute opening argument, reserve 15 minutes for rebuttal. Mr. Irons will have 15 minutes, and then Mr. Rayner, you'll have 15 minutes as well. With that, Mr. Collins, please proceed.
Aloha, ai olo ai ka'aha ho kolo kie. Aloha and may it please the court. This case is about the proper review and disposition of a challenge to an erroneously granted Chapter 343 exemption. HRS 343-6A7 permits exemption declarations when there will probably have minimal or no significant impact on the environment. This court has indicated a four-part test based upon the administrative rules most recently enunciated in Umberger. In the Super Ferry case at 115 Hawaii, summary judgment was appropriate because the agency did not consider whether the project will have minimal or no significant impact on the environment. And in that case, the court specifically said exemption determinations made by agencies shall be reviewed as a matter of law. That's at page 318. However, in this case, the Intermediate Court of Appeals determined that there was a genuine issue of material fact as to whether the action will have a significant impact on the environment. And this is the problem with that determination and why it is grave error. 343.2 defines an environmental assessment as a written evaluation to determine whether an action may have a significant impact. And for the purposes of the statute, impact and effect are interchangeable as demonstrated by the finding of no significant impact definition. Trial on a significant impact would replace the entire purpose of the preparation of an environmental assessment and the environmental assessment process, which would include community participation, and it would shift the burden improperly to community group, and it would not be a systematic review of all of the effects that a proposed action could have on the environment as that's defined both in the purpose at 343.1 and the intent of the statute as a whole. 343.1 specifically says that the quality of humanity's environment is critical to humanity's well-being, and that our activities have broad and profound effects upon the interrelations of all components of the environment, and that an environmental review process will integrate the review of environmental concerns with existing planning processes of the state and counties and alert decision makers to significant effects which may result from the implementation of certain actions.
Mr. Collins, Justice Edens has a question.
You know, whether the exemption applies as a matter of law was sort of the first words out of your mouth, but you know, the law always needs a set of facts to operate. And don't we need some more facts here?
Your Honor, for purposes of an exemption, our position is no. First, it's the agency's burden to properly make that determination. And if the record of the agency doesn't disclose that it was properly granted, or that there is a genuine issue of material fact as to whether there's a significant impact, then the agency could not have properly made the exemption determination. And that is the purpose of having an environmental assessment, is to go through to determine whether or not there are significant impacts.
So as I saw it, the circuit court, you know, didn't evaluate 3 of the 4 exemption factors. The ICA sends it back. I mean, could the ICA's opinion just be sort of saying, you know, come on, get your act together right from the start, versus that there's really some disputed facts, and that's where we need to go here?
Well, the ICA said that the issue of material fact has to do with the significant impacts. And the problem with having a trial over that issue is that it would completely replace the environmental assessment process. That is the purpose of an environmental assessment, is for the agency to evaluate all of the potential significant impacts. But if we have a trial over that issue, and the circuit court determines that in fact there's a significant impact, then there won't be an environmental assessment. Because if there's a significant impact, the statute requires the agency to prepare an environmental impact statement. And so by having a trial as to whether or not there's a significant impact, the result is that it completely removes the environmental assessment process from the statutory scheme. And there's an entire range of benefits to having an environmental assessment that by having a trial would eliminate that. You know, one is that it diverts agency resources, and it also shifts the burden to public interest groups that may not be able to, you know, definitely will not systematically look at an action and will only, you know, devote their resources to the specific issues that they are able to present to the court. So that would be the, I would say that those would be the main issues with substituting a trial at the circuit court for an agency proceeding with an assessment.
Justice Devens has a follow-up question. Justice Devens.
Thank you. Counsel, if the case goes back to a trial, does BLNR get a second bite at the apple to show negative or no impact or minimal impact?
Well, our position is no, it shouldn't. You know, our position is if a public interest group or somebody with standing comes to the circuit court and demonstrates that there is a probability of a significant impact, to the extent that the other side cannot demonstrate as a matter of law that it will either have minimal or no significant impact, that itself means as a matter of law, the exemption is not proper. And that it needs to go to an environmental assessment. And by remanding it for a trial, it's essentially allowing the BLNR to create a record that in fact it didn't have, and it didn't comply with the process, and it shouldn't be allowed to remedy that at the circuit court. It should just prepare an environmental assessment at that point.
And is it your position because BLNR got their one shot at it, that's the reason why summary judgment should be entered in your client's favor?
Yes, unlike the Umberger and Carmichael case, where the issue of an exemption was completely absent from when it was at the trial court the first time in both of those cases, the exemption issue was never addressed by any of the parties. The first time it was at Umberger, and the first time it was at Carmichael. So when Umberger came up and the Umberger court added, or they modified the superferry factors to determine an exemption and sent it back and remanded it for the court to consider those issues, none of the parties had addressed that issue. They were fighting over whether it was an action. And the Carmichael, it was a similar situation. The issue of an exemption was in no way addressed before the trial court. So those came up, and then after Umberger went down, Carmichael came up, and then it also went back down. And the issue of an exemption had to be addressed. But in this case, all of the parties briefed the issue of the exemption. Umberger came out before the court considered the motions for summary judgment. And so in this case, everybody had the opportunity. I mean, I'm sure if you've looked at the record, there's, thousands of pages of documents. And so it wasn't like this was something that escaped anybody's argument or review. I mean, this was a central component of the circuit court's analysis. And so it's not clear what would be the basis to allow the state or Syngenta an opportunity to basically get a second crack at summary judgment, or whether or not it would even be appropriate to consider anything else because it's not in the agency's record.
Mr. Collins, what about discovery? I think I recall reading in Syngenta's response sort of allusions to the need for discovery, possibly of state officials, permitting files and the like. What's your take on that?
Well, Your Honor, discovery is very important in many types of cases, and in many ways it levels the playing field. But there are certain types of cases, particularly with review of government action, where discovery can end up being abused. And in this instance, the agency should have provided what the basis was for their determination. They had the opportunity to do that. And it should have been a matter of public record because they have to make this exemption declaration. If people have to be deposed, or files that were secret to everybody in the world have to be discovered, that seems to be further evidence that the agency did not make the proper decision. The agency makes its decision based upon its record, and if there's all of these other issues that would be suitable to discovery, then by definition, it means that the agency did not consider what it was supposed to consider. And under superferry, as a matter of law, the exemption determination is not proper.
What about, what do you think the agency, I mean, as I looked at the board's determination, there was a staff report which basically said, as I understood it, exempt because this is continuing the same activity that had been going on for a while. There'd been, I think there's also a reference to the CDU back in the 80s. What do you think, what level of detail do you think we should be looking for from an agency in assessing the issues that you think should have been assessed, like cumulative impact? Is that something the board should have taken a time out, come back with a further developed, more further developed written reasons for why it was rejecting or why it was adopting the exemption? What do you think we should be looking for in these kinds of cases?
So I think the problem in this case is that the negative declaration in 1982 was for growing cane seedling. It was not supposed to be for experimental seed operations. That was something that got added after the negative declaration to the CDUP. And so the seed experiment operations, that was never subject to anything regarding 343. And so with respect to that, the purpose of 343 is so that government decision-making is informed by what are the impacts to the environment. So the seed operation was not in any way reviewed by 343. So the reliance in 2015, 2017 by the agency of that negative declaration didn't cover the actual uses that were being proposed. And it is true that they were taking those actions, before the granting of the RP to the previous entity. But under the statute, that does not give them shelter. The actions that are given shelter, the uses that are given shelter, are uses that are already subject to a previous determination, and there's no change in use and there's no change in impacts. And that didn't occur here because the uses that were being reviewed were never evaluated through the 343 process.
Right, we have Justice Devens has a question followed by Justice McKenna.
Thank you. Counsel, the negative declaration from the record, did that only apply to KAUHU's sugar operations, or did it also apply to Pride's seed cultivation project?
Your Honor, the negative declaration applied to Pride's cane growing operation. KAUHU's cane growing operation. The seed operation from Pride was something that was added to the CDU P after it was approval after the negative declaration was not considered by the negative declaration, the agency in making the negative declaration.
And is it true that the BLNR's current conclusion of an exemption was based in part on that negative declaration from 1982?
It was based. It was based on that, and that there had been no change in use from that negative declaration.
Although the negative declaration only applied to the sugar operation.
That's right. That's right.
Thank
And you know, I would just mention that, you know, as far as I understand it, you know, sugar growing operations, I think they were using glyphosate as a defoliant at some point. Not sure if it was in the early 80s, but definitely by the 90s they were using it. And they use chlorine to keep the drip pipes from clogging up with algae. But that's the extent of what I would consider pesticide use for the most part with the cane growing operations. But the seed operations are a completely different story. And the seed operations, even in this part of Kauai, have repeatedly been found to have improperly used some of these chemicals against workers and in ways that have impacted nearby schools. So, the seed operations are much more like the pineapple operations, where they're just dumping stuff into the ground and doing stuff, as opposed to the sugar operations, which very minimally used restricted use pesticides and that kind of thing for their operations. So I just wanted to mention that there's a difference between. It's not just like, oh, well, they're growing corn versus sugar. It's that the whole operation is entirely different.
Well, Justice McKenna.
Mr. Collins, does the record include information as to what, I'm really not familiar with this area, what is around this area and how far is it from the ocean and what is around this area?
Sure. So this area is next to the ocean. Makai is the ocean, and basically downwind is the ocean, and which is one of the reasons why Surfrider and Kohola Leo, which is a whale marine mammal organization, got involved with concerns with that. There is some in there. Sorry, there's I think there's shrimp somewhere in the general vicinity. But I can't tell you. It is somewhere in the record, but at this moment I can't pinpoint exactly where it is. There is a highway Mauka of part of the parcel, and I believe there's a drag strip somewhere in the vicinity as well.
Is there corn being grown by other farms or others anywhere in the area?
That I'm not sure, but if it is, it would probably be Mauka of the highway, but I'm not 100% certain because I'd have to look at the map, which is in the record. That it is in the record because we made sure that it would be in the record.
Very well, Mr. Collins. Anything further at this point to wrap up your initial presentation?
Your Honor, I would just say that, the evaluation of an exemption determination, and if somebody challenges that determination and they can show that there's a probability of significant impacts, to the extent that the ICA or some other court would determine there's a genuine issue of material fact as to a significant impact, that on that ground, that as a matter of law, the agency did not comply with the correct procedures for an exemption, and that an assessment should be prepared. And in our view, that is very similar to, in some ways, to a warrant where law enforcement officials prepare and demonstrate to a specific level of detail factual information, and then it goes on to the next step in the process. You don't have a trial. If someone disagrees with the facts that are in a warrant, you don't have a trial over that to determine whether or not the warrant is valid. You go on to the next step. And we, in our view, it's a similar process here based on super ferry, which indicates that exemption determinations are evaluated as a matter of law. Thank you. I'll reserve the balance of my time if I may.
Well, thank you, Mr. Collins. Mr. Irons, your argument.
May it please the court. Before addressing the exemption, there's a preliminary issue I want to discuss, which is mootness. Syngenta Hawaii LLC no longer owns or operates the seed farm at issue in this case. The business has been sold to Hartung Brothers, and they've owned it for approximately 5 years. They've gone in and gotten a new revocable permit, RP 7903. So at this point, Syngenta no longer has an adversarial stake in this matter. We would request that on remand, the court direct the circuit court to dismiss Syngenta and then determine in the first instance whether or not the case should proceed in Syngenta's absence. I think effectively relief probably can't be granted without the current permittee involved in the proceedings.
Mr. Irons, Justice McKenna has a question.
Yes.
Thank you. I'm so sorry. I think I missed where in the record this was raised.
Well, it was in each of the briefs that Hartung Brothers is now the permittee, that they took over.
Did you file a motion to dismiss based on mootness?
No, we haven't. When the decision was not affecting our interest because it approved the permit, the lower court decision was in our favor, there wasn't a need to make a motion to do that. Now that it's being reversed, then we certainly will make that motion. And I just say that I think the issue won't escape judicial review because it's already been addressed. And I agree 100% with the plaintiff's counsel that the super ferry case is directly on point, but I read the case differently. When you're looking at a HEPA exemption, what the court said at 315 is that it depends on the specific question that the court is concerned with. So there's questions of law that could be decided as a matter of law, and there's questions of fact that cannot be. And in the super ferry case, the determinative issue was one of segmentation. So what the Department of Transportation had done was they defined the project narrowly as just a pier expansion, where they knew full well that it was going to be used as a terminal for the super ferry. And so by limiting and narrowing the definition of the project, they were escaping environmental review. And it was undisputed factually that if the super ferry had been part of the project description, that exemption would not have applied because that's a major project. And so the court had no problem in that particular case determining that as a matter of law in this case, because of this segmentation issue, which is procedural, the exemption doesn't apply.
Mr. Irons,
this case is different.
Mr. Irons, do you agree that with Mr. Collins that the initial negative declaration was based on an understanding or based just on the sugar cane planting?
Well, so I think I need to explain a little bit more. When the revocable permit was granted in 2017, the Board of Land and Natural Resources was looking at extending or renewing a month-to-month occupancy permit, a tenancy. It was not looking into use. And I think the only reason they referenced that was to show that there was a CDUP on the property. They didn't get into the environmental review in any significant way because frankly for them, they were just doing name changes on the permit. They were changing the rent and you had a static permit and it was on land that was already being operated on. So static land, resource, static permit, no changes. So they weren't in a position at that time to develop a full record on the environmental review. And this is not a case of a contested case hearing where there's been an administrative review and there is actually an administrative record. This case is brought directly as a declaratory relief action under HEPA. So the only so-called record would be the staff report that was submitted. But all the claims that are raised in the complaint 3 months after the agency makes its decision raise new claims, new issues that the board could not possibly have dealt with at the time, including this issue of going back 40 years and challenging the use permit that the parties have relied on to conduct their agricultural operations. Now that use permit was not challenged back in 1982. There was a subdivision also that was not challenged in 86. On both of those occasions, there was a negative declaration for the first, and then there's a negative declaration for the second subdivision approval. And what's important to know is we call the negative declarations today would be called a FONSI or a finding of no significant impact. But prior to issuing that declaration, there's a process of preparing a draft environmental assessment. That goes out for public review. Then there's a final environmental assessment that goes along with the FONSI. So my point is there's an entire record there that has not been developed. And yes, it would require discovery, but it wasn't an issue because we're not dealing with a use permit. The use never came up. We're dealing with an occupancy permit to continue the existing occupant. And so if they wanted to challenge the current operations and that they're outside the scope of the permit, which runs with the land and continues, until it's terminated by the agency, then they would need to bring an administrative proceeding, a petition for declaratory judgment or relief before the agency. The agency would then hold a contested case. They would review all the evidence, create an actual administrative record, and then the plaintiffs could appeal, or the petitioners could appeal to the circuit court, and then the court would have the full and complete record. In this case, that didn't happen. That's the whole point, I think, of the ICA's opinion, that it's not that they couldn't, if they had all the facts, make the determination of whether the exemption should apply or not apply. It was that the record was incomplete. And it was incomplete because of both parties' fault. The plaintiffs didn't attach the revocable permit to their motion for summary judgment. We didn't attach it to our motion to dismiss or in the alternative motion for summary judgment. And so the evidence that was before the ICA, the record on appeal, is simply the documents that the parties chose to attach to their motions. That's what went up on appeal.
Mr. Irons, if I could, Judge Hammond has a question, and then I have one as well. Judge Hammond.
Yes, I was just going to ask if you can address the argument that's made by the petitioner regarding the difference between Carmichael and Umberger.
Well, so Umberger, I think, and Carmichael are both similar in that they deal with resources that fluctuate from year to year. The fish population can go up and down. The watershed can go up and down year to year. So if you have a static permit and you're taking the same amount of fish in 1 year, it could have an outsized impact if the fish population is very low. In Carmichael's the same with water. If you're drawing water, you could have the same amount of right to withdraw water, but could have outsized impacts from year to year. So I think both of those cases dealt with resources that fluctuate, and there had been no environmental review of either of them. So they're both cases of not an exemption, but no environmental review. And what the court said was, okay, these revocable permits, even though they're month-to-month tenancies, because they've gone on for a long period of time or they go to year, there needs to be some sort of environmental review. And so the court sent it back in both cases to the circuit court to look at the facts and determine whether or not an exemption might be applicable. And I think those cases, it makes more sense for the environmental review on the program to be conducted so that you can address the fluctuations in the resource and develop maybe some mitigation for the program. And then subsequent approvals would probably be exempt based on the prior document. But when in our case where we have static land that's not changing year to year, and we have a static permit where all we were doing was at the request of the BLNR was to change our name from Syngenta Seeds to Syngenta Hawaii LLC, which was a wholly owned subsidiary of Syngenta Seeds. So there wasn't an actual change in who was the permittee, it was still Syngenta. And then on the government side, you had a portion of land that went from the Department of Ag's arm, which was the Agribusiness Development Corporation, that gave a license to Syngenta, that they then transferred the managerial, I guess, responsibility over to DLNR. So that's all that was happening in this permit, and the rent was altered higher.
Mr. Irons,
yes.
I think that, Mr. Collins had sort of argued that, nevertheless, it is an approval to do something on this land or to continue doing the activity on the land. And, I thought I heard you say something that it wasn't until 3 months later when the complaint was filed that the board was even aware of some of the arguments being made by the plaintiffs in this case. But if I understand correctly, Gary Hoosier had submitted written comments to the board that in essence argued that there could be a cumulative impact and there had not even been a cursory environmental review performed. And that was presented to the board before it, went ahead and approved the staff submittal. So what at that point, was the board free to simply ignore that, or should it have engaged in some way and made actual findings?
Well, I think the board did make findings in its determination. It did find that there'd probably be no minimal impact from this. And they were taking into consideration what specifically the action was. And I think it keeps being conflated that this was some sort of a use permit. This was a month-to-month tenancy. So if there wasn't an underlying use already approved, the permit would have granted possession, but not any particular use, no development rights. All those would have to be approved independently, and they had been. And like I said before, if they really want to challenge the existing use permits, that was something, they still have an avenue to do that, but it's also something that could have been done originally. So I think what you have to consider is, in general, the rule of reason. And if you are taking an action where there was a name change on a permit and a change in rent, and you're saying, well, we're also going to look at the existing use as part of the project's impacts, then you are opening this up to well beyond what the statute requires. If you look at the definition of environment, so are we having an impact on the environment? The environment includes, and this is under Hawaii Administrative Rules 11-200-2, environment means humanity's surroundings, inclusive of all physical, economic, cultural, and social conditions that exist within the area affected by the proposed action. It includes everything that's there. And I think what's happening in this case is there's a confusion about the action as including the existing operations. And I'll just say that I think all the ICA was doing was saying the record is not complete in this case because you don't have the revocable permit, you don't have a summary of what the existing operations are. Therefore, as a factual matter, we can't say whether or not this permit fits within the Class 1 Item 52 exemption, that it'll have negligible impacts on the existing environment, meaning existing operations.
We have questions from Justice Stebbins and Justice McKenna.
Thank you. Counsel, by the ICA finding that there's a genuine issue of material fact relating to environmental impacts, isn't that really a ruling that BLNR didn't carry its burden of showing no impact and therefore summary judgment should be granted to KAUHULU?
No, as I was just saying, I don't think that's exactly what they said. What they said was the record on appeal doesn't contain sufficient evidence or facts. And so in a case where you don't have an administrative record, and it in fact does need to be developed through the case.
But we operate on whatever record is submitted to us. I mean, that's on the parties.
Right, so the record on appeal, what I'm saying is not the same as the administrative record. The record on appeal is only what the parties chose to submit with their dispositive motions at the very beginning of the case, before we've gone through anything. And I do want to say, when the plaintiff's counsel says, oh, we'll have to go through trial, I don't believe you'll have to go through trial. You would just do some discovery, get all the documents, be able to go do the full permit history, see what all the environmental review was, get more information about the existing conditions on the ground, and then you bring your motion that you have enough facts.
Shouldn't that have been done when the summary judgments were filed? I mean, that was the time to do it.
Right, but that works for both sides.
Right.
So I agree. I lost my motion for summary judgment because they found a disputed facts, and the same holds true for the plaintiffs.
Right, and we just operate on the record on appeal, and it is what it is at this point. So I'm not sure what discovery we're talking
about. The discovery, well, one, it would be getting the actual revocable permit, so you can compare how it might have changed from the prior revocable permit that had been issued, that had been canceled and reissued, and then you would get facts and information about the existing operations to see if there's any incremental change that might occur that could have an environmental effect. And so, and then we would have a defense if there's prior environmental review. We could use that as a defense to requiring further environmental review. But all that would need at least some written discovery to make sure we have all of the documents from all the past, history of permits and review, so that you could have an informed decision.
Justice McKenna. Oh, you're muted. I'm so sorry.
Mr. Irons, thank you. You indicated that you thought that the ICA had said that, because the RP was not a part of the record, et cetera, therefore things needed to be reviewed, remanded. But I also heard you seem to be suggesting that this really was not an action that required environmental review. And my understanding is that the ICA made it very clear that this was an action triggering HEPA review. And the cancellation of the Syngenta Seeds RP and the issuance of an RP to Syngenta Hawaii was an action triggering HEPA review, and that issue was not, there was no cert app. So we're operating here under the assumption that this was an action. And then you're indicating that upon remand, there should be discovery so that the record can be fully developed. But hasn't this court already ruled in KIY that while plaintiffs are allowed to present extra record evidence An agency cannot rely on extra record evidence as a substitute for the analysis that the agency was supposed to perform. And so this really is not a real fight between your client and Mr. Collins' clients. This case really deals with whether the agency performed its obligation to do a review of an action. And this has been determined to be an action. And so therefore, it appears that we do review the record the way it exists right now to determine whether or not we can rule that as a matter, whether it can be ruled as a matter of law that there is no impact or no significant impact. And it seems to me that if there is a genuine issue of material fact as to that, pursuant to the Super Ferry case, environmental review is required. But please explain to me why you would disagree with that analysis.
Well, I'm not here to say that it's not an action. I'm resolved that that has been decided by Carmichael and the Court of Appeal, and I didn't take a writ. The writ is only about whether the exemption, the categorical exemption that was adopted by DLNR and went to the Environmental Council for review, whether that exemption has been complied with. And I think my only point with the ICA is that their decision was that there's not a sufficient record on appeal because of how early we were in the case. Syngenta hasn't even answered the complaint in this case. And so they said, we don't have enough evidence on appeal. And they also said that the judge didn't actually go through all the Umberger factors. I think somebody else mentioned that. That's true. And so all it is, well, if there's not a sufficient record to make this factual determination that's necessary to make the legal determination, then we send it back. And the discovery, if you wanted it very limited, it would just be, okay, let's get the revocable permit as part of whoever brings a motion. Let's get the existing operations that are being conducted on the site so that you can do a comparison to the existing environment, and then what probable impacts, if any, that the permit could have on the environment. But it would not be to look at the impacts of the existing use. I think that is the bridge too far that I think the plaintiffs want you to do or to take.
Mr. Irons, we're about pushing 7 minutes over your allotted time. Anything you want to wrap up with for the court before we move to Mr. Rayner?
I appreciate all the extra time, and I'll let Mr. Rayner speak.
Very well. Thank you very much, Mr. Irons, for your argument. And Mr. Rayner, please proceed.
Good afternoon, may it please the court. Ewan Rayner, Deputy Attorney General, arguing on behalf of the Board of Land and Natural Resources. Your Honors, I think this case does raise an opportunity for the court to provide some probably needed clarity regarding the question of what standard is to be applied by a reviewing court when an agency's exemption determination is challenged under HRS 34-7 as it was here. And specifically the extent to which that review, the court's review, is can be based on legal and or factual questions. So in our view, this is not a situation in which the board's exemption determination can just be overturned as a matter of law because it did not consider the proper factors or follow the proper procedures. But instead, it's a case where a legitimate question has been raised as to whether the board got its factual determinations, its factual exemption determinations wrong as a factual matter. And the fact that the petitioners have presented evidence in the circuit court that creates a genuine issue as to whether the board erred in determining that the action would probably have minimal or no significant impacts does not mean that the petitioners have established that the board was wrong as a matter of law. In other words, while, as the ICA held, while the record was not sufficient to grant summary judgment in favor of the board and in favor of Syngenta, that does not mean that the petitioners are automatically entitled to summary judgment in their favor. And at minimum, we think the case should be remanded so that the circuit court can at minimum, consider the exemption factors that it didn't consider the first time around. As the ICA held, it only considered the first of the 4 exemption factors and didn't reach the second, third, and fourth factors. And that's especially true in light of the fact that whereas here, the new evidence was presented to the circuit court that wasn't before the board. So to exempt an action from HEPA, the agency has to consider 4 things. So first, it has to consider whether the action falls into an exemption category that's promulgated either by the Environmental Council or by the agency itself. And second, whether it doesn't have a significant cumulative impact or a significant impact on a particularly sensitive environment. And then they must consult with other agencies that have jurisdiction or expertise on the subject matter. And finally, it has to determine that the action will probably have minimal or no significant impact.
Mr. Rayner, Justice McKenna has a question.
Thank you, Mr. Rayner. You indicated, I have 2 questions. First, do you agree with Mr. Collins that the initial finding of no significant impact was made without consideration of the seed operation?
Yes, I agree with Mr. Collins on that. I mean, the record kind of speaks for itself. It only the FONSI. It's so what? Just to clarify, the negative declaration itself didn't include the seed farm operation, only the sugarcane. The CDUP itself, though, did authorize both uses.
So the second question I have is, you indicated that the circuit court considered evidence that the agency didn't have. What are we talking about here? Because the ICA has already determined that this is a new action. The new RP to Syngenta seeds, Syngenta Hawaii, was a new action. And why wouldn't environmental review be required as a matter of law for this new action?
So
are you saying that there's a question of fact as to whether or not there is a potential significant impact?
Well, that's certainly, I think, exactly what the ICA found. And I think, so the reason, my answer would be, the reason it can't just be reversed or vacated as a matter of law, the exemption that is because, in the cases where the court has done that as a matter of law before, it's been where the agency has failed to consider one of the necessary factors for an exemption. And so what this court has explained before, that for an exemption determination, it's not a question of the level of documentation, at least as the legal questions. It's a question of whether the agency made the appropriate determinations. And then when that's challenged, there are 2 parts to the challenge. One, the legal question is whether the agency made the necessary determinations and considered the necessary factors. That's a legal question. And the second question is whether the agency then, whether the agency's factual determinations were clearly erroneous. Now, usually in an agency appeal, in the normal agency appeal, and I'm talking about outside of the HEPA context here, the clearly erroneous standard is something that can be determined as a matter of law, because you're limited to the agency record. And it's a question of just looking at what evidence did the agency have before it, and in light of that evidence, did the agency, what was its
did the agency not have these affidavits or declarations of Mr. Hooser and the other individuals who indicated there was pesticides being sprayed that was spreading, and that this is close to the ocean?
So no, all of the declarations and all of that evidence was presented in the circuit court, not in the board. Mr. Hooser did raise a concern at the board meeting. He raised a concern about the use of pesticides, but the declarations and the studies regarding pesticide use, etc., were presented only in the circuit court. And so the circuit court's record is much broader than what was before the agency. And I think that is in large part what the ICA's decision was getting at, because the ICA reversed finding a genuine issue of material fact. And I think there's 2 reasons for that. One is because the circuit court had not
All
yet.
right, I'm sorry, I'm just, Mr. Irons referred to a new RP to a new entity 5 years ago. I'm a little bit unclear. Was an environmental assessment done for that?
You're referring to when
The
the
new
revocable
entity that apparently took over.
No, so that, well, I think Mr. Irons is referring to this when this revocable, what led to the board issuing this revocable permit was Syngenta's request to issue a revocable permit in a new corporate name, changing from Syngenta LLC to Syngenta Hawaii.
Well, he's saying that it was sold and somebody else has it, and there's a different RP now.
Oh, so okay, so it's so the operation itself was sold to the Hartung brothers. Now that happened long after anything happened in the record of this case. That's a recent development. So, you know, I don't.
He said it was 5 years ago. I'm just wondering, was environmental assessment done for that one with the agency having information regarding pesticides?
You know, I'm not sure. I mean, that's certainly not in the record of this case because it happened after this case came up. But so I'm not sure what environmental review was done for that. I don't believe there was, but again, it's not part of the record here, so I can't answer that definitively.
Mr. Rayner, to the extent, so Mr. Hoosier raised concerns about cumulative impacts and the lack of any environmental review having been done on this project and the use of highly toxic chemicals. And the staff report simply says, well, they're doing the same thing here. And it, by the way, it refers to operations use or personnel will not be changing. Was there any obligation on the board, particularly in light of this comment having been submitted to it, to examine the issue of cumulative impacts? And if it failed to do so, and there's a record presented to the circuit court that there were cumulative impacts, why wouldn't that be a basis for granting summary judgment?
Well, I mean, I guess there's a couple of points to respond to that. So the board, I think, did a little more than find that just that there was there was no change in the use. So the board also found, as part of its exemption determination, that the lands had been in agricultural use for many decades, which had resulted in no known significant impacts to the natural and environmental resources in the area. And so I think even though, you know, I will concede that the board did not explicitly address the concerns raised by Mr. Hooser. But I think, you know, implicit in that finding that I just read is you know, because that concern was raised before the board, implicit in that finding is the board didn't believe that concern rose to the level of there, you know, being probable significant impacts on the environment. And you know, I guess it's a question for the court to answer whether it's necessary for the board to explicitly explain why, you know, every possibility that's raised to it does not require an environmental assessment, or whether it's sufficient for the board to just find that there are, you know, based on the record before it, that there's probably no minimal or no significant impacts. And in regard to the you know, that evidence being before the circuit court and why that doesn't lead to summary judgment being granted in favor of the petitioners is because there was evidence presented on the other side of that too. You know, it wasn't a case of the petitioners presenting the evidence of the concerns regarding the use of pesticides, and then that evidence was never rebutted. There were declarations. Syngenta attached declarations and evidence to its memorandum in opposition, which rebutted that evidence. And so I think that's largely again the basis of why the ICA found that there was a genuine issue of material fact as to the question of whether the board erred in finding minimal or no significant impacts.
So ultimately, this case could go to trial. Is that consistent with the sort of the process of, you know, relatively quick and early decisions about providing adequate information to the decision maker?
Well, I mean, I guess,
These
you know,
cases go to trial now if there's a disagreement about, you know, how much the pesticides were sprayed or where they were sprayed, or is that what you're advocating for?
I mean, you know, technically, I guess the case could go to trial. I mean, I think as a practical matter, I don't think that's likely, and I think probably, you know, the case is remanded. I shouldn't think any of the parties really would be advocating for the, you know, for the case to ultimately go to trial. And in other cases, you know, for example, where in Umberger, where the case was remanded after the court found a genuine issue of material fact on the exemption issue regarding recreational permits, you know, that didn't go to trial. That was dealt with on a renewed motion for summary judgment, which could be the case here as well. So it's not necessarily a case of it necessarily going to trial. It's more of a case of requiring the circuit court in the first instance to address all of the 4 exemption factors, which it didn't do the first time around. And the reason I think it's necessary for the circuit court to do that rather than the appellate court is because what I referenced before, the fact that there is new evidence submitted to the circuit court. So it's a question of not only a question of the circuit court going through the 4 exemption factors and determining whether the board clearly erred in its factual determinations, but it's a question of it doing so in light of the new evidence that's been presented to the circuit court, which ultimately, you know, is a factual issue. And that's why I think this court in Carmichael indicated that those kind of determinations are, to quote, within the purview of the circuit court rather than the appellate court.
That's just a thing that you got about a little more than a minute to go, but if you have other arguments you'd like to address to the court, please do.
Okay, I mean, I'll try and briefly summarize. So ultimately here, the board determined that authorizing the revocable permit would probably have minimal or no significant impact on the environment in the area. And we believe it considered the appropriate factors, and in doing so, and the board asked only at this court allow remand for the circuit court to settle in light of the evidence presented to the circuit court, plus any additional evidence the circuit court deemed appropriate to take on remand, the question of whether the board clearly erred in its factual determinations. And I just note again that I think that's especially important in light of the fact that the circuit court here did not get past the first exemption factor. And so I think it's necessary to allow the circuit court to, in the first instance, address those questions. So unless the court has any further questions, we would respectfully ask that the court affirm the ICA decision and allow the circuit court to consider the factual questions raised by the remaining 3 exemption factors that the circuit court did not consider.
Mr. Rayner, if there's a dispute about what kinds of pesticides were used, where they're used, how much of them are used, and the court finds that's a disputed question of fact, then this case, wouldn't this case go to trial?
I mean, like I said, it could do potentially, but you know, the point I'd make about that is, even if that were the case, the question would not, just to respond to Mr. Collins' argument about it's sort of replacing the EA process in the statute, it would still be a question of whether the board's exemption determination was proper. It wouldn't be replacing the environmental assessment process. And so it would be, I think, a very limited question. It would be very limited to the question of whether the board clearly erred in concluding that there were minimal or no significant impact. So in our view, it wouldn't be replacing the environmental assessment determination. It would be a much narrower issue than that, if in the event it were to ultimately go to trial.
Very well, thank you for your argument. Mr. Collins, your rebuttal.
Thank you, Your Honor. May I ask how much time I have remaining?
I'm going to check. Give me a second. About 12 minutes.
All right, thank you very much. Your Honors, I would like to respond to a number of issues that were raised. The first is the sufficiency of the record, in our view, does include public testimony to the agency. It includes agency comments. In this case, the Office of Hawaiian Affairs raised their concerns to the board, and that the agency responded to that. I mean, in this particular instance, the EPA had publicly notified everybody that they were investigating Syngenta for serious labor violations of that harmed workers and that were hospitalized. So even in those types of instances of these well-known, publicly known facts, the agency can't just say, well, nobody came to the board meeting and testified. And that goes to the sufficiency of the record. But definitely when the public does go to a board meeting and says those things, the agency has to meaningfully engage in that and give it a hard look. I would also note that the map of the area is at docket 25 on page 83. With respect to Mr. Iron's mootness argument, our position first, of course, is that a revocable permit of this type is subject to a mootness exception as capable of repetition but evading review. The revocable permit was issued for 1 year in 2017, and we are here in the appellate process in 2024, and we feel that it satisfies those requirements, but separately, it also satisfies the public interest exception because there are important public questions that the cert application raises, and there's a desirability both by the community and by the government to get a definitive determination, and this is likely to recur if this court does not give a definitive determination to these questions. With respect to my friend Mr. Irons' question about well, the decision was made 40 years ago, and so that's why the exemption was proper. The 343.7 is a statute of repose. And so that means if you do not challenge the action within the timeframes, there's different timeframes for the different types of 343 issues that are raised, you cannot raise that issue again. However, if there is no 343 determination and the government has to engage in another discretionary approval, that reopens the statute of repose. And you cannot shelter in the fact that you somehow were able to get your action approved without complying with 343. So the statute of repose is very strict, but you only get to shelter in whatever you previously got. And if you had nothing, then you don't get to shelter in the lack of a previous environmental review. It's just a statute of repose. It is a statute of repose, and an agency or an applicant cannot benefit from the fact that there was an incorrect or non-existent previous environmental review. It's just like a commercial paper and a holder in due course. If you're a holder in due course, you get all of the benefits and you're shielded from all the personal defenses that the maker might have. But if you're not a holder in due course, then you step into the shoes, and whatever you got is what you got. And our position is that because the statute of repose is so short, and that people who do get approval should be able to take comfort in that. But if there was no review, if they have to get further approvals down the line, then it reopens that process, and they can't benefit from the lack of proper review previously. And that is specifically stated in 3431 that the environmental review is supposed to inform all of the decision making in the process, not just the very first one in the very first time that somebody can connect to something 40 years ago.
Collins, could you address Mr. Iron's argument that this permit was really relatively narrow in scope? It really wasn't addressing issues of use of the land, but more focused on the tenancy of the property and a transfer from one entity to another, but it really was not one that engaged with the issue of how the land would be used, and therefore those issues really not raised in this process, or didn't need to be raised or addressed.
Well, Your Honor, if there had been proper environmental review, then as I just indicated, then they could shelter in that distinction and basically say, well, this has already been reviewed. And this is sort of the similar logic to Flores, that, well, once you get one contested case, you don't get a second contested case by the same parties over the same issues. I think that's the general thing. The problem is that there was never any environmental review for the original uses. And so when a discretionary approval comes up, the agency is supposed to be informed by this environmental review. And if there's no environmental review, then they haven't been informed by it. And so the fact that there's this, in my mind, somewhat of a futile distinction being made between use and purpose. If they did not have an RP, they could not use the land. So the fact that the agency is approving the possession and that somehow became a severed or separate approval from the use of this conservation district area in the CDU-P process yeah, it's true. And if there had been the appropriate environmental review for the seed operation, then his client would have been able to shelter in that. But you can't shelter in an erroneous review. And I think it's very clear that the 343 exemption that's in the record specifically says that it's being exempted for the use of state lands. So I still also think that sort of distinction about possession versus uses in terms of the RP is not really true, or it's a very technical and futile distinction to make. And that's at docket 25, 76 and 84. That's the agency's determination for the 343 exemption that the staff prepared. We'd also say that it's, the other parties did not make a Rule 56F request for a continuance. There's no affidavits indicating what additional information they needed. Actually, what the record does disclose is that after we filed our motion for summary judgment, all of the parties stipulated to continue for 10 weeks that hearing to give Syngenta the opportunity to file their motion for summary judgment, which they did on August 30th. And then 10 weeks later, we had a hearing. There are no 56F requests for continuances. So this is not like the Ralston v. Yim situation where we're just saying like, well, you had your chance and you didn't do it. They didn't ask for anything. They thought that they showed what the record was that the agency used and it wasn't sufficient. And now they're asking to go back and have a trial over the issue of whether or not there's significant impacts. And one concern is, as Justice McKenna indicated with Kia'iwai, is that there is a difference between the agency, what the agency can present to justify its decision, and what the plaintiffs can present that the agency failed to consider. And if this goes back and we have to have a trial, I hope that we don't have to do extensive discovery and we don't have to have a major trial. But in my experience lately, with this hesitation to grant summary judgment in challenges to government approvals, what we are seeing as practitioners is that the state is deposing volunteer representatives of our community organizations, and we have to spend lots of time sitting in depositions so that they can go through every conceivable aspect of our client standing and things like that. It happened in the Navahine case. It's happened in several Maui cases recently. And so that's one concern, is that, well, they didn't follow the rule that should be decided as a matter of law, but instead my clients, who are basically all volunteers, are now going to be spending the next 6 months having to deal with a bunch of discovery requests, and then maybe or maybe not we'll have summary judgment again, and maybe it'll come up again, and then maybe it'll have to go down again because the agency wants to do more discovery. So that's the concern.
Help me, I think it was Mr. Rayner who said, yes, of course, the plaintiffs put in a great deal of information in support of their summary judgment motion, but the defendants disputed that. There was issues of fact that were raised, I guess, about, whether whether the information about the use of pesticides pertain to this particular property or not. And I guess I would ask you, to the extent there are issues of fact, is that something that we do need to go further on? What exactly should the burden be on a plaintiff coming in this situation to raise questions or to establish a basis for challenging the agency's exemption decision? And to the extent there are disputes about just how significant the impacts are, something that might have been omitted or forgotten, how do we resolve those?
So in my view, if as a matter of law, the court cannot find summary judgment for the state, then the matter needs to be remanded to the agency to conduct an environmental assessment, because it's the weighing of that information which is the entire purpose of the assessment. And then the agency will make a determination about whether or not there's significant impact. And if there isn't, then they'll make a finding of no significant impact. And if there is significant impact, then EIS will have to be prepared. So the standard in my view is that if the agency is not able as a matter of law to obtain summary judgment saying that the exemption was proper, and in this case the ICA said there was a genuine issue of material fact, then it should be sent back to the agency to do an environmental assessment. So I would liken it to the metaphor that I used regarding a warrant, that if a warrant is issued, you don't have a trial over whether the warrant was proper, although I know our former president tried that like a year ago in Florida. You move on to the next step. Well, you're supposed to move on to the next step, and that's usually what happens. And in this instance, the next step would be for the agency to prepare an assessment.
Justice Judge Hammond, your question. Oh, you're muted still. I'm sorry.
But this is not an agency appeal, right? So how can it be remanded back to the agency? Isn't this a complaint that was filed in the circuit court?
Yes. So yes, that is correct. So we would be asking for summary judgment in our favor to indicate that the agency would need to complete an environmental assessment. That's correct. It's not a remand as in terms of agency appeal. But the effect would be that it would be sent back to the agency to take further action if in fact they're going to be taking further action.
Very well. We're coming up towards the end of your time, Mr. Collins. Anything you wanted to share with us to wrap up today?
Yes, Your Honor. I would just ask that the petitioner appellants request that the ICA be reversed as to the question of a genuine issue of material fact. That instead the plaintiff appellants are entitled to judgment as a matter of law, and instruct the circuit court to enter summary judgment for the plaintiffs and to declare that the agency is to prepare an environmental assessment in this matter. Thank you very much.
Very well. Thank you to all of our attorneys for your arguments today. The court will take this matter under advisement.
Ua ho'oku'u ia mai ne kea aha ho'okolokolo ki eke hanohano o ka moko'aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.